I did want to give you, everything that we're presenting here is in your binder, plus a few other goodies in the front. To go over what those are, if the Department of Labor ever decides to audit your plan, the first letter is what they will expect you to have in relatively short notice. This is an actual letter that was given to an employer, and this is relatively recent. And the plan inception was 1993, and they expected collection of documents from 1993 onwards. So record keeping is one of the things that we're going to be discussing today, the importance of it, and the understanding that throwing it in a file may not be your best interest, but it's what most people do. And so talk about that. And then the secondary piece, which we will touch on later, is a self-assessment as to, okay, if I am an administrator, a fiduciary of a 401k, this is a quick acid test as to how we're doing, what we could be doing better, that sort of thing. We hope for all yeses here, no question marks, no, I didn't expect to have that. So this will be going over later, and if we have any questions to that. The third piece is also very important because I am quite certain that A, I could put you all to sleep very quickly, but B, I normally do this in a much smaller group basis. And so feedback is very important as to how we can improve the presentation and what we can do to make it a more useful and productive piece of your time. We want to make this the best possible presentation. So, honesty, at the end of the session today, I would love your feedback. So, with that, the couple of questions that I have for everybody in general is, and most people are not aware as to their fiduciary status. Who's considered, the question I would ask in general is, who is considered a fiduciary on a 401k, 403b, 457b? Do you think it's just the people that sign it? Sign the 5500s or the related tax documentation?
Or the people that manage it also, like the administrators?
They're all administrators, all officers within the company. And it's not just corporate liability that's associated with it, it's personal liability as well. If something were to go wrong with a plan, you were to be attached, you were to be examined by the Department of Labor, that is not just a corporate examination, it can be a personal examination as well. Now, a lot of people are under the impression that, oh, I have hired Merrill Lynch, I have hired Charles Schwab, I have hired these various entities to assist me. They are running the plan. I'm hands-off. You can actually never give away fiduciary liability. It can be delegated, but it can never be given away completely. And so if I would like to, the goal of today is to go through a process that we found to be very effective to have in place. One that you take into account your foundational piece, which is your documents, how you go along implementing that, your monitoring process, and then your follow-up. So, again, as we go along, I'm going to try to stop us every hour to check A for pulses and see if anybody's asleep. As I said before, feel free to go to the restroom, excuse yourself, and we will have refreshments shortly.
Can I ask a quick question?
Sure.
How often does the DOL come in and examine these things? Does there have to be a complaint in order for them to come?
No, actually, and that's what's very scary about recent legislation. The Department of Labor has gone through great efforts to A, go through a hiring phase, and B, part of that hiring phase is that they are very cognizant that there are some places where small employers, large employers even, are not compliant. The 401k idea, the 457 idea, where it's, I have nationwide, they are taking care of everything for me, is very common, when in reality, unless co-fiduciary status is in writing, and we'll go through that in our tags, if there was an examination and you went to your vendor, be it Merrill Lynch, Charles Schwab, whomever, and say the Department of Labor is coming in and they're doing an audit, unless they are co-fiduciaries, the feedback you would most likely get is, well, good luck with that. It's essentially the idea of, I am a Buick dealer, I've sold you a Buick, and you go in your drive and take out the concert pianist. You can't go back to the Buick dealership and say, I'm glad we're in this together. Because the Buick dealership would say, I just sold you something. So Has it been pretty frequent? Yes, actually, it's very salient in the Roanoke market. There was a physician's practice, and I know that none of you are from doctor's offices, that recently went through Department of Labor IRS audit and was hit with $600,000 worth of personal sanctions. That was not covered by their insurance. It was out of pocket because the plan was considered top-heavy and discriminatory. So no, it's not just because of a complaint. It can happen, and we feel that with the broadening definition of what a fiduciary is, and part of what our topic is discussing today, there is method to the madness as to that it's going to be more aggressive as opposed to less aggressive. They're gearing up to make it unpleasant. So, yeah. Any questions with that, or is that? Okay. So what we hope to achieve in this grand scheme of things, and I am not great with PowerPoint, the best shot. Everything that is in PowerPoint is on your slides, and as we go through, please feel free to stop me. What we hope to achieve today is to promote a culture of fiduciary responsibility and improve the decision-making process of investment fiduciaries. And the first question you might have is, okay, well, Margaret, where are you getting this stuff from, and how are we achieving best practices, and are you pulling this out of thin air? And what we're going to present today is a blending of industry best practices, legislative case law, and IRS and Department of Labor opinion letters. And we're pulling the best of those, translating them to English, and hopefully giving you something that you can bring back to your businesses and implement on a real-time basis. Okay. So the first question we would have, or the first thing that we want to emphasize, is who is an investment fiduciary? Most of the time you go into companies and they are under the impression that an investment fiduciary is only relegated to the person that signs the 5500s, the decision maker in the plan. HR managers are considered fiduciaries, and under the new Department of Labor definition of fiduciaries, all of their tertiary employees, corporate officers of the plan, and corporate officers of the company would be considered fiduciaries as well. Something goes wrong in the plan structure, it is top-heavy, there is finding by the Department of Labor, everybody is on the hook. Investment fiduciary also takes 3 different sections. We have stewards, which as in your roles, that's what you are acting as. There are investment advisors, who you would hope would be your Merrill Lynch's, your Charles Schwab's, your anybody else that you would hire to assist you in this. And then there is the investment managers, which are the mutual fund companies that are behind it. Investment fiduciaries have fiduciary liability, and they try and attempt to delegate it to investment advisors and investment managers. Investment advisors are only fiduciaries if you A, have it in writing, and B, it's something that you can pull out and show the Department of Labor as to, okay, Merrill Lynch is advising my plan. They are on the hook with me. Any documents you were asking me to pull, have them pull as well. Most HR managers, people that are administering plans, are under the impression that that's the way that it is. It is not. It is actually incredibly rare and unusual for an advisor to accept co-fiduciary status because of the liabilities associated with it. This includes Fidelity, this includes all of the major players. As a matter of fact, with new Department of Labor legislation that's coming out, they are asking and requiring advisors to accept co-fiduciary status in writing. Now, if you read any of the opinions that are associated with that, Fidelity, Merrill Lynch, Charles Schwab, all of the major, Wells Fargo, all of the major wires are pushing back and saying, no, how's that? Because for the most part, a co-fiduciary status is accepted. It's for very, very large plans, $100 million plus. Because for them, the juice is worth the squeeze. They can put the insurances and the potential people towards the plan to ensure that it is compliant. Your 5500s are filed on time, that there is nothing else that could draw red flag notes to the plan. Scary. Very, very scary. What is going to be the result of that, or what we feel will be the result of that, is that places like Fidelity, Merrill Lynch, Charles Schwab will stop allowing their advisors to actually do 401k plans. It will become, good morning.
Good morning.
It will become the domain of what we would call registered investment advisors. Registered investment advisors differ from your brokers at Charles Schwab and the like because they don't have the same securities licenses that require them to know the difference between a stock, a bond, a mutual fund. They are essentially there. We are coming to you as an advisor, but we are not securities licensed. We know about it, but we haven't had to go through any government-regulated training in order to be so. We just have had to show that we are financially liable. We haven't had any bankruptcies in the last 7 years, and anybody can do it. So that's why it's very, very important to be with the people that have feet on the ground to make sure you guys can protect yourselves. Any questions? Fiduciary excellence is what we are striving for. With investment stewards, they create fiduciary excellence when they collectively fulfill their roles to a standard defined by law, regulation, and best practices. We have taken quick acid tests of all three, and we formulated this plan so that you can, again, bring it back to boots on the ground. Stewards manage the investment decision-making process, and it is considered an area of ultimate responsibility. Fiduciary responsibilities can be shared, but not abdicated, i.e. hiring, a record keeper hiring anybody else is saying that I'm delegating to you, but you were ultimately responsible for their actions. Liability exposures exist where there are unfulfilled responsibilities. Most unfulfilled responsibilities, plan sponsors are not aware that they have them. And as we go through, ignorance is not a viable defense. I didn't know, I shouldn't have known, is not something that's going to fly with the Department of Labor or the IRS if they become very interested in what you are doing. Now, the ways that we can avoid these liabilities is by identifying gaps and filling in with best practices. If we have the foundational piece of documentation in place, you cannot prevent actions from happening. You can be very prepared for them. We are simultaneously preparing for war and peace. Have it done, have it filed, have a process that's discernible, and then should an action ever take place, you are well protected. These are the laws that are most apropos and apply most to 401ks. If we are, ERISA is the big one. ERISA is the one that is associated with ESOP claims, 401k claims. It is federal. It is large. It is the 900-pound gorilla that is comprehensive of everything. If you think that you're an expert in ERISA, you are not. I am not. I know one small section of ERISA very well, and the rest of it is gobbledygook. I don't know. UPIA is the Uniform Prudent Investment Act. This normally oversees private trusts, and if nothing else fits in what you're doing, that's what you would use UPIA for. MIFA is special for foundations, endowments, and government-sponsored charitable institutions. These UPIA, MIFA, and MPERS are all state regulations, and they are overseen by the State Attorney General. ERISA is federal. So what is it that we can do to protect ourselves? Know the standards, laws, and trust provisions that are applicable to your particular plan and your role. Diversify assets to a specific risk and return profile. This is where a lot of people have a level of discomfort because that's in their idea. That's why we hire our advisors to do that. This is not my special place in the sun. I am an HR manager. I am an administrator. Don't you know that I've got enough to do? And a lot of employers put in place 401ks, 403bs for the benefit and retention of their employees. They think that they're doing good. It's very tax efficient for the companies if they were to do that.